All right, good morning, Your Honors.
Good morning.
May it please the Court, my name is Joseph McAfee of the Greene County Bar. I represent Mr. Hill. If I may reserve 5 minutes for rebuttal, please. This is a case where the record is pretty clear as to what took place in the timeline. Mr. Hill is alleged to have committed 4 offenses on April 1st, 2019. He was charged May 2nd, 2019 with 2 counts of aggravated rape, 1 count of incest, and 1 count of sexual battery by an authority figure. The case proceeded to trial November 3rd and 4th, 2021, upon which the jury convicted him of those 4 counts. The issue that we raised in our brief first noticed. So
Let me ask, did you have a written copy of the instructions before they were given to the jury?
I'm not sure, Your Honor. That may be something that's not in the record. I was not the trial counsel. The instructions provided by the court were comprehensive as to the charge of aggravated rape. The instructions included the options for the jurors to find that the defendant, Mr. Hill, was guilty of the offense of aggravated rape by the use of force or coercion, and in the presentment, which is in the record, Mr. Hill is alleged to have committed the offense by the use of force. And by the court instructing the jury that they may find Mr. Hill guilty by force or coercion, it lessens the burden on the state and in effect makes it possible for the jury to have all found Mr. Hill guilty. By the jury form, it says aggravated rape, guilty or not guilty. It doesn't say the way that they found those elements to have been reached, by injury or by force or coercion. So there's no way for Mr. Hill to have been apprised previously in the record that he was going to be on trial for a charge of aggravated rape by coercion, and coercion can include, of course, attempted use of force. Also, count 4, the sexual battery by authority figure, as it was charged in the presentment, he's alleged to have committed that by use of his parental authority. In the jury instructions, it includes methods for the jury to have found the state to have met its burden of proof, of course, by the use of custodial authority. At the top of the presentment, not in the body of the presentment, it seems to allude to the use of parental authority or position of trust. Anyway, the instructions say position of trust, custodial authority, or parental authority, when the presentment itself simply says parental authority. Have a pretty clear record. It establishes what occurred in terms of what was charged, what was instructed, and what the jury found in terms of the verdict. They found him guilty, but we don't know exactly how they found him guilty and under what elements. It's a clear and unequivocal rule of law. The defendant has the right to a correct and complete charge of the law. It was his substantial right that was affected, not waived for tactical reasons, and part of our support for not waived for tactical reasons is the record does not have any indication of why or how that particular instruction was entered, or any tactical reason for the trial counsel to have not raised an objection or raised an issue there. And upon review of the record itself, it's unclear why someone may have waived that. So this needs to be considered for substantial justice purposes. This is an argument that supports the rule of law and holding not only the defense.
If nothing else, you can't prove substantial justice, because the state's entire argument all through the trial and in closing was that it was based on an injury, that there was nothing else was mentioned about these other elements that may have been wrongfully included. It was all about the injury, and the proof was overwhelming about the injury. So how do you meet the plain error standard if that is correct?
Your Honor, I mean to be respectful by responding with a question, but how do we know what the jury found? He's entitled to a unanimous verdict. There may have been 6 jurors back there that found, well, we found that he used force. Maybe another 6 jurors that Well, we
That's
don't
part of the,
define
but that's
force,
part
but
of the
we define
standard.
coercion.
But that's part of the standard is that you have to prove that, you have to show that a substantial right, excuse me, there's a substantial injustice here. And one of the ways of doing that is looking at the proof, and the state's argument is there was no proof about anything other than an injury. And that proof was
Well, the instruction, or the presentment was by force, and the injury, the state has argued that the proof supports there being an injury. I would respectfully submit that the force element is not as strong as the injury testimony. I mean, we know that injury can be anything from, bruising, cutting, any sort of something that causes bleeding, or simply testimony about pain, and that the record supports that. But the force or coercion, that it just seems like it kind of muddies the water, and we are unclear as to what the jury found. And the proof may be one way or another, but if we're entitled to unanimous jury verdicts, there's no way to tell.
The force or coercion charge, didn't it also include an element that it was, that the defendant used what was fashioned or was a deadly weapon, or weapon designed in a manner to make the victim believe that it was a weapon? Was there any proof about a weapon?
No, sir. No, Your Honor. And
So that was part of the force or coercion charge, though, all in the same
that was
sentence.
part of the jury instructions, yes, Your Honor. And if I'm not mistaken, there may have been an instruction on the coordination with another person. I can't remember the exact language of the statute, but if I recall, that may be another method of proving aggravated rape. And we focused on the force or coercion argument because of the coercion definition, including the attempted use of force, which of course lightens the burden of proof on the state. The other argument that we raised is as to the sufficiency of the reference to pain.
Good morning, Your Honors. May it please the Court, Garrett Ward here on behalf of the State of Tennessee. Your Honors, this Court should affirm the defendant's convictions for aggravated rape and sexual battery by an authority figure because the evidence is sufficient to support these convictions, and his complaint about jury instructions doesn't rise to the level of plain error. Your Honors, I'm actually going to start with sufficiency because I think talking about the elements of this charge and how the state met them informs the way this Court should analyze the jury instruction issue. We are here in this case on sufficiency, primarily on the aggravated rape charges. Aggravated rape, Your Honors, essentially always has two elements. The first is sexual penetration, and the second is any one of a number of aggravating circumstances. I'll reiterate any one of these circumstances. One of these circumstances is simply bodily injury. That is how this case was charged, was aggravated rape with bodily injury. And that's exactly what the proof showed. The victim testified in no uncertain detail that she woke up in a room other than the one she fell asleep in, with her pants and undergarments pulled down around her ankles, with the defendant on top of her, and that he proceeded to penetrate her with his penis and with his hands. She testified that this process hurt. I'd submit to the Court that in the light most favorable to the state, this rather easily checks all the boxes for sufficiency of the evidence. As I understand the defendant's argument related to sufficiency, particularly related to injury, the complaint is that the victim's testimony was a little unspecific on which act of penance. It's not part of the elements for aggravated rape by bodily injury. So I respectfully, Your Honors, when my friend on the other side talks about the element of force or coercion, that's not an accurate description of the conviction offense here, which is rape by bodily injury. So unless this court has questions on the sufficiency of the evidence, I'll turn to the jury instruction, which I really do think is informed by what the elements of this offense actually are. And Your Honors, I'll acknowledge on this jury instruction issue from the beginning that the state's presentment did deal in specific theories, both tacked to the pattern instructions for aggravated rape and sexual battery by an authority figure. Judge Holloway, I believe you asked a question about was there a copy of the written instructions furnished to defense counsel prior to the charge being given to the jury. I can't say for certain that exact exchange isn't in the record. There is a copy of the written instructions, and then there is, from my recollection, a discussion of having reviewed the instructions when a defense counsel at trial chose to waive oral argument. He said something along the lines of like, I'll stick with the instructions or rely on the instructions. So whether he had a chance to review them or was given the exact same written copy that's in volume 2 of the record, it's clear that these instructions were furnished to defense counsel at trial. What's equally clear is that there was no objection, which means that, as opposing counsel seems to concede, that we're here on plain error. And Judge Dyer, I think you got right to the heart of plain error in this case, and that's the plain error requirement of a showing of substantial justice sort of demanding consideration of the error, and we just don't have that here. Certainly, Your Honors, the trial court's instructions were a little bit broader than the theory charged in the presentment. But while the court did talk about, or did give an instruction on, I believe, simply the deadly weapon charge, or the deadly weapon variety of aggravated rape, there's no proof about deadly weapons in this case. There's no argument about weapons in this case. What there is a lot of proof about injury and a lot of argument about injury. And since we're viewing this through the the magnifying glass of plain error, and we have to, we're looking for, is there substantial justice that requires this to be considered, given the way this case was presented, given the way this case was argued, and given the fact that the trial began with the presentment being read to the jury, so the jury's mind is focused from the beginning on not deadly weapons, but on bodily injury. All the proof was on bodily injury, and all the argument was on bodily injury.
Hypothetically, let's say one of the witnesses had mentioned something in passing about a weapon being present. Does that change your argument here? Even though the state would have stood up at closing and not mentioned it itself, but if a witness from the witness stand, which is evidence as opposed to argument, had mentioned a weapon, does that change your argument here?
Your Honor, there is probably some quantum of evidence on a deadly weapon that would bring us into the realm of substantial justice, perhaps requiring consideration of the error. I don't know that I would say sort of a singular passing mention would get us there, but I take the point of Your Honor's question to be inquiring is there a point where just evidence, even if the state isn't arguing it, might trigger substantial justice, and there likely is, but that's a case and a question that we don't have here. We don't have that, not even a passing mention, and certainly not enough to distract the jury from what the state charged and what the state proved in such a manner as to require consideration of the error under substantial justice. And I'd say the same holds true for the for the sexual battery by an authority figure. Your Honors, it is clear from the proof and from the argument that the state was operating under a parental authority theory in this case. That's the way the presentment, which again was read to the jury at the outset of trial, was charged. Tragically, Your Honors, rather all that this case is about is the fact that the minor victim's biological father was out of her life for about 10 or 11 years, that she reconnected with him, and that 3 months later he raped her. This entire case centers on the fact that the victim and the defendant are father and daughter. There's no suggestion of any of the other theories of sexual battery by an authority figure really being at play. So I think this court's analysis should proceed rather identically to how it should proceed for aggravated rape, and that's we have a case here where the state's proof, the state's argument, and the presentment read to the jury are all in lockstep. There's no extraneous proof, extraneous argument, and then we have this instruction that is broader, but given the lack of proof or argument about this extra language in the jury instruction, we're not at a point where substantial justice requires consideration of this error. And I'd like to sort of conclude, Your Honors, by...
May I ask one other question?
Certainly, absolutely.
I assume there was an election.
Yes.
Okay. In the election, obviously, the entry, the instrumentality, so to speak, and the body part that it was entered, but is that all that it said? Because one's vaginal, one's anal, right?
No, Your Honor. One is there's a digital and a penile penetration. So that was the election.
But no descriptor other than that in the election?
That's my recollection of the election, Your Honor. That it was sort of an election on form of penetration, not necessarily what was penetrated.
What accompanied it, so to speak?
Yeah.
Okay.
But, Your Honors, I'd like to briefly bring us back to force and coercion, because that seems to be the crux of the defendant's argument for substantial justice, is that we don't know whether the jury found force or found coercion, because the way the jury instruction was, and frankly, the way the presentment was that the jury needed to find force or coercion and bodily injury. Your Honors, I'd submit to this court that it only inured to defendant's benefit that the jury was considering force or coercion at all, because that's not an element of this offense. The elements of this offense are, as I've said, sexual penetration and a bodily injury. There is no requirement for force or coercion, so substantial justice doesn't require this court to consider any error in the trial court instructing the jury to find force or coercion, because the jury wasn't required to support this charge. The only party that was harmed by this particular jury instruction error was the state. It imposed an additional burden on the state that the statute doesn't. And given that, substantial justice doesn't require consideration of this error in the jury instructions either. Unless this court has further questions, I would just ask that you affirm. Thank you, Your Honors.
Thank you, counsel. All right, Mr. McAfee, you have your 5 minutes of rebuttal.
You know, taking up the substantial justice element of a plain error finding, the defendant, he's entitled to a fair trial, not a perfect trial. And if we don't grant him a new trial, well, let me take it back right quick. Just in terms of sort of isolating exactly what the arguments are, if we have only one count of aggravated rape, here we have two, and the jury instruction does not include a coercion. So we have a presentment, count one, force and injury. Then it sort of takes away the jury instruction argument and the sufficiency of the evidence. But when we add a coercion instruction, it sort of splits things in two, and it's hard to tell whether the defendant's basic protections of a fair trial have been met, because we don't know what the jury found. And you know, if you know, we have to have trials serve their functions to try and do justice, not only to the state and the alleged victims, but also the defendant here. So without granting him a new trial, then we can't be sure that the trial was fundamentally fair and that we're following the law here, as painful as it may be. So that would certainly This would be my summary on the jury instructions argument. And unless the court has any questions or inquiries to make as to the sufficiency argument, we would ask primarily for a judgment of acquittal, and in the alternative for a new trial on counts 1, 2, and 4.
Thank you, Mr. McAfee.
Thank
Were you
you,
appointed to do this case on appeal?
I'm sorry.
Were
Your
you
Honor.
appointed on this case on appeal?
No, Your Honor.
Okay.
I was retained.
All right, well, I was going to thank you if you were, but I'm glad to hear either way.
But it's usually a pretty good guess.
A lot of times we have, our court has to appoint
you.
counsel on appeal, but we're glad to hear.
Yes, Your Honor. It's usually a pretty good guess I'm appointed when I'm down here, but I appreciate it.
I didn't mean any insult by it at all. All right. Ready to call next case, please?
State of Tennessee versus Scott Allen Briggs.